Attorney Marc Lopez,
with Zach Bailey.
and we are talking about a recent trial victory that we had here in Marion County. Fantastic case. We love all our clients. We had a client with a CDL. Driving was super important to them. They owned their own business, and having a CDL was part of that business. And basically, they said to us, "Hey, Marc, Zach, if I get convicted of this, I'm gonna have to change my life, change my lifestyle." He's not going to die or anything like that, but it was going to change his way of doing business. And so, we told him, "Hey, we take all these cases serious, but when someone tells us like that, and we know anybody with a CDL, DUI is pretty harsh. The federal government treats DUIs with CDLs very, very harshly. It doesn't even matter what you can negotiate with the state." So Zach and I came up with a plan of attack. In this particular case, we did depositions. Why do we do depositions in this case?
It's always important to know what people are going to say ahead of time. It's also important because we can lock them into that story. Time passes, things change, but we know exactly what they're going to say. And if they say something different on the stand, we can say, "Well, that's not what you told us back when we talked to you before, is it?"
That's super important. And locking in individuals with their statements, it's fantastic because you know what's going in there. There's always a balance, though, because when you do depositions, we've both been prosecutors. And when somebody sets a deposition, you have your ears perk a little bit because what's their issue? And smart prosecutors can sometimes figure out what the issues are when you do depositions. So we do a lot of depositions with this law firm, but not every single case because we don't want to tip our hands too much. In this particular case, we knew for certain they were going to have timing issues. And when we say timing issues, Zach, what do we mean?
So in an OVWI case, if there's a blood draw or a breath test or anything like that, you have 3 hours from the time they last operated until the time of that test, where that test is presumed, whatever the result comes in, it's presumed that was their result at the time they were driving. In this case, there were about, from the time they found our client to the time they did the blood draw, it was about 2 hours 35, 2 hours 40 minutes. So they were right up against it anyway.
They were so close. And in this particular case, we knew, even if the prosecutor figured out what we were going to argue, they weren't going to be able to magically figure out a time of the actual collision. And so in this case, we did depose the first assisting officer. Zach, without getting too much details, what did the first officer find?
He found our client had driven what he assumed was the wrong way down College, popular street here in Indianapolis, hit a pole, and had crashed his car, and he was there when he arrived on the scene.
So again, our client was outside the vehicle. The officer came upon him outside the scene, transported him to the hospital for a blood draw.
Yep.
At that point, another DUI officer, a very seasoned officer, came, started asking clients questions after he Miranda'd our client. The client made all sorts of crazy admissions. Much better idea to plead the fifth. Come on. Always saying this, but hindsight's 20/20. How did the trial go, Zach?
It was dismissed midway through. 41B.
41B. That means that the judge didn't even say, "Hey, not guilty." The judge said there's not even enough evidence to go forward. During the trial, we were able to kick out the blood test. We were able to demonstrate that he was in an accident due to slippery conditions. And why is that important, establishing there was an accident?
In this case, it's really important because the signs of intoxication the state was they had to rely on also were signs you would see after a crash. Slurred speech. They used the HGN test, the test where they give them the eye test. And after an accident, especially a serious one like this, you're likely to see somebody with nystagmus just as a result.
An unsteady balance, an accident. And to give credit to these officers, they wanted to win. And I give these officers so much credit because they didn't lie. They didn't embellish. They said, yeah, after an accident, people can be unsteady. After an accident, you might have slurred speech. You might have red glassy eyes. Obviously, they were trying to win, and they would follow that up with, yeah, you might be unsteady on your feet, just like you might be after drinking alcohol. So they were trying. They're doing their absolute best. But at the end of the day, the burden isn't most likely. The burden's beyond a reasonable doubt. In this case, the judge said, without the blood test being admitted, she has no more proof that this was alcohol, signs of alcohol consumption versus being in an accident. And she did the right thing. Obviously, we're very happy about this. And our client is ecstatic as well because he's back to his normal way of life. It took forever. I won't lie about that. The state continued the case numerous times. We wish justice could always be swift,
Mhm.
but we prefer correct justice over swift justice any day of the week. Any parting thoughts?
Just always plead the fifth.
Always.